I'm Mark Trexler with the Climate Web, which you can visit at theclimateweb.com. Now, climate liability, climate litigation, one of many topics that we track pretty comprehensively in the Climate Web. And there have been some recent developments in that space that I wanted to make sure that you were aware of and provide a little bit more context for some of the recent headlines. So if you come down here, it's all chronologically ordered. There's a note that in October, judge resurrects San Francisco suit against the oil companies for sea level rise damages. Now, this suit had been dismissed and appealed in the middle of 2018. It was filed in September of 2017. But now a federal judge has ruled that the case does belong in California state courts, after all, in what is generally perceived as a defeat for the defendant oil companies. And I'm not going to go into more detail on that particular case. You can dig into it more in the Climate Web if you want to. But three others that I think are worth a little bit more attention. One, Dutch court dismisses damage claims by RWE and Uniper. Two, Puerto Rico sues fossil fuel companies under RICO statute. Three, scientists sue EPA for failing to regulate greenhouse gases under the Toxic Substances Control Act. Now, these are all very recent. To give a little more context to the Dutch court ruling in November, this brings in the whole idea of investor-state dispute settlements. And I'm going to jump to one of our Climate Web dashboards specific to this topic. These dashboards organize topical sources, headings, present some of the key reports, some of the key news stories, videos, other things around specific questions. Environmentalists have been concerned for a long time. And let me just open up the notes field here so you can just see how you can open up these stories. Have been concerned for a long time that some of the provisions of international trade agreements could provide for companies to recover from countries when they implement climate policies and recover for foregone profits. And so when the U.S. turned down the Keystone Pipeline, TransCanada filed a $15 billion suit against the U.S. government under exactly provisions. And there's a very good, if you haven't seen it, there's a very good podcast out there called Damages. And in season 2, episode 2, the episode has to do with secret tribunals. And it is specifically around this whole area of how these disputes and dispute settlement processes work. Very worth listening to if you're not familiar with the topic. Now, why this Dutch court dismissing this claim? They had submitted claims for about $1 billion apiece having to do with being told they're going to have to shut down coal plants in 2030. And so they sued for foregone profits. And the court turned it down because the court said, look, this was foreseen a long time ago. You should have anticipated this as part of your due diligence 5 years, 10 years, even 15 years ago. And so it is inappropriate to now say that you should get billions of dollars because the government is basically doing what it said it was going to do a long time ago, arguably, in the Framework Convention on Climate Change in the early 1990s, when basically all the countries of the world agreed to avoid dangerous anthropogenic climate change. So this is a big deal that this judge has said, no, your due diligence should have turned this up a long time ago. And so the idea that you can now claim damages just doesn't work. And it'll be interesting to see whether we see the same thing happening in other courts. The next topic I wanted to briefly cover is the regulation of greenhouse gases by the Toxic Substances Control Act. And why that's relevant here is that an environmental group had petitioned the EPA to open up a rulemaking proceeding to regulate greenhouse gases under the Toxic Substances Control Act. That was denied earlier this year, and they have now filed suit against the EPA to try and force them to act on this petition. Now, it's worth noting that this goes back a while. The Toxic Substances Control Act was relevant to the regulation of CFCs under the Montreal Protocol many years ago. And back in 2015, let me just expand this a little bit. Back in 2015, some of the same petitioners had actually filed to get the EPA to act, and the EPA didn't act at that time. And there's been some, not a huge amount, there's been some discussion out there in the last couple of years of could the Toxic Substances Control Act be a useful adjunct for tackling climate change and greenhouse gas emission. And there's one particularly interesting point that I came across from a GRIST post in 2015, where they're basically noting that the Clean Air Act is designed to cut down on the amount of air pollution being produced, letting nature take care of the rest. The Toxic Substances Control Act, in contrast, is designed to deal with toxic chemicals which don't necessarily just dissipate. So it can be used to require not just forward-looking efforts like pollution controls, but remediation like biosequestration of carbon through tree planting and wetlands restoration. And so it is a potentially quite different tool to try and bring into the game. And the argument being that carbide and carbon dioxide and methane are, as agents causing climate change, toxic substances. It seems counterintuitive, but it'll be interesting to see how it plays out. And again, you can come in and take a look at a lot more literature in here. It's interesting to note that same podcast, Damages, its most recent episode covers this new suit in some depth, along with the last of the topics that we're talking about today. So track down the Damages podcast, very informative on both this issue of the TSCA suit and on the last issue that we're going to cover today, which is RICO litigation on behalf of climate change mitigation. So RICO is an interesting case. Racketeering statute is initially designed to go after the mafia, as I'm sure you're well aware. Come over here. One of the interesting things about RICO is that we've seen RICO applied to going after climate activists as well. And Greenpeace in particular was gone after in a number of years ago. And so this effort to use RICO on climate change has gone both ways over time. Now, the topic has been around for a while. There were calls to start investigating oil companies and fossil fuel companies under the RICO statute back in 2015. And the fossil fuel industry has been pretty vocal about saying that this is simply an abrogation of free speech, that it's totally inappropriate. But this new case by Puerto Rico, and if I just jump in here, the case is right over here. You can read through it, but they have a whole series of causes of action. What's really notable about this case is there is a big focus on RICO. And so it's really being called the first major case to focus on RICO in going after the fossil fuel companies. It's not the only case. They have 14 causes of action, but it's a big cause of action. And they argue that defendants acted to increase fossil fuel usage, that defendants' actions were reckless, that there was a meeting of the mind between defendants to make all of this to happen, and that defendants knew what would happen to countries like Puerto Rico given the future effects of climate change. So again, the whole topic of law and liability and litigation around climate change has been pretty tricky, even though it's been going on now for the last 20 years. Hard to know how this particular case will pan out. Although in this case, it is interesting to note that if we jump over to the oil sector chronology for climate change, one of the challenges that the oil sector has here in particular, but not just the oil sector, but fossil fuel sector, is that you can come back and you can find Exxon scientists in the 1970s telling management that fossil fuels will warm the planet. And they were getting regular information about this. And Exxon's director of research was talking about we probably will have to significantly curtail fossil fuel usage prior to the year 2000. So there was a lot of this discussion going on. A 1978 Exxon memo warns that humanity only has 5 to 10 years before hard decisions regarding changes in energy strategies might become critical. And that was a lot of people were talking that way in the early 1980s. And then suddenly in 1989, the industry as a whole did an about face and launched the Global Climate Coalition, which then became a major mouthpiece for efforts to prevent international progress on climate policy and all sorts of other things. So there is a big record out there that clearly the plaintiffs in this and other litigation are going to try and bring in. And the RICO aspect is an interesting new aspect that we'll have to see how it plays out. Thanks for watching.